Appeals Division 1 is now in session.
Please be seated. This is the time set for oral argument in 1 CACB 20-0487 FC, Gelin versus Murray. Council, I remind you that we have read and considered the pleadings in this matter. We've discussed this matter in conference. Both sides have 20 minutes to present their case. Appellant's counsel, I would remind you that if you wish to have any time for rebuttal, you need to manage that yourself. And these proceedings are being recorded, so when you begin your presentation, if you could announce your name and which party you represent. Please remain at the podium, and you can remove your masks if you so choose while you're speaking. And with that, Mr. Shields, I think you may begin.
Thank you, Your Honor. Good morning. My name is Mark Shields. I represent the appellant mother, Cindy Murray. She is here. Trial counsel Robert Newell is also present. Now, I need to begin by addressing my duty of candor. On page 8 of my opening brief, I made the statement that there was no reported case that dealt specifically with this issue, with this part of the statute. In preparation for oral argument, I found the Valentine case that was provided to the court with supplemental authority last week. And also with my duty of candor, I need to point out, as I'm sure Mr. Beeks was going to point out, that the statute had changed since its incarnation as cited in Valentine. To that end, I have applied, and the clerk has been very helpful in furnishing to the court copies of the statute as it existed then. What I would like to point out is simply the quote from Valentine, stating first, we hold that any award of past support, we're going to hear that term many times today, reaching back until the child's birth is mandatory. To that end, the version of 809 as it existed at that time and tracking the changes since then has not changed in a way that would affect this case. 809A as it existed then still had the two main terms that are at issue today. That is, first of all, shall, meaning it's mandatory to enter that award, and then the term past support, referring to this specific period. The 3-year limitation was added as B later on that year in the legislative session, and that's where what brings us to today. That brings it more in line, brings the issue more in line with the case, the unreported case that I cited pursuant to Rule 111, that is perfectly on point dealing with this issue. Now, if
I may, past support, any amounts of money entered prior to the child support order would be deemed past support, correct?
In the context of this statute, that is only partially correct because we have two different periods addressed. The opening brief was very careful to delineate those terms, past support as it appears in 809A and as it appears in the second sentence in 809B. I believe that's the whole convolution of the issue here. Notwithstanding Petro, which is very clear, but not mandatory, and now with Valentine, which is mandatory, it really does boil down to that past support distinction.
Well, hold on, you didn't answer my question. So, a Superior Court judge who issues a child support order and directs that a prior amount of monies be put towards child support, that's a past support order.
In the context of 809A, it would be past support if it were prior to petition. If it were in the context of 809B, and I apologize I was taking so long to answer the question, that would be support since filing of the matter. The legislature addressed both of those periods. So past support could be considered generically either one of those, but in the context of this statute, it is specific to an amount from before the filing of the petition.
Well, past support, I thought past support was the demarcating line between arrearages, which is only that amounts that accrue after the entry of a child support order.
Again, it may or may not be depending on the situation, because those terms can be used generically. What we are looking at, and it's very important to do this under the de novo standard, this is where the de novo standard really means something, is these two sections of 809, 809A and 809B.
Well, it's not generic because arrearages accrues interest, past support does not.
Correct.
So it's important to determine legally what is past support and what is arrearages.
Correct. And may I submit that the first section of 809A, using that word shall, applies specifically to past support. Then we see the term past support again in 809B in the second sentence.
So any award amounts of monies prior to the entry of the child support order would be past support. So they're saying you have to pay past support, but it begs the question on what that means, because it's any amounts of money prior to the entry of child support order, doesn't it?
That question would be answered by Valentine, and it would be answered by Petro versus Giannini. I believe it would also be answered by parsing these out correctly. Again, the first sentence in 809B is specific to support since filing of the action. From there, that term past support comes up again. We are left to connect dots. Under the Petro ruling, under the Valentine ruling, it's not hard to connect those dots. Those dots go from, to make it clear, the first section in A, past support, and then the second section in B, the first section in B, support since filing of the action. Then the second section in B has to revert back. It's a dot that only makes sense if it's connected back to 809A, that specific period of past support. And Your Honor, just for clarification's sake here, interest has not been argued. I understand where the court's going with that. I think I do at least.
Well, I'm telling you, it informs me, because when the statute says past support, that's a term of art that specifically recognizes that's monies that have been imposed upon the obligor. Did I get that right? The obligor that are not subject to interest, meaning that's past support. It's prior to the entry of the child support order.
Correct. Also, under that term would fit the first section of the first sentence, I should say, of B. Now, let's look at it. I want to point to the answering brief because I think it conflates this issue. To me, there's no question it conflates the issue. Starting on page 8 of the answering brief, Mr. Beek states, subsection B specifies 3 relevant periods. First period is the time between the filing and entry of the child support award. Okay, I dispute that there are 3 relevant periods addressed in subsection B. I don't dispute that the first one is the time between filing and entry of the support award. That should be clear. It is met with a shall. It's mandatory. But it doesn't end there because following that, also on page 8 of the answering brief, he states this is the period for which an award is mandatory under subsection A. Well, no. A is the period that is mandatory under subsection A.
Well, Mr. Shields, you may be overreading subsection A. The way I read it, it says the court may, or the court shall direct an award, an amount, if any.
Correct.
Right? So the
Correct.
court can determine that no such past support is due.
If we are applying, well, there are 2 reasons for that. One would be because there may be voluntary payments, as there frequently are. The other may be simply a matter of time. Actually, there are 3 reasons. For example, many paternity petitions are filed at the time of the child's birth. I've even dealt with some that were filed before, so no, there wouldn't be any past support on that. And the third condition is what's stated there in A, and that is it's subject to equitable defenses. So any of those 3 scenarios would be addressed. And in that case, that would be correct. There would be no past support because either everything had been paid or we're starting at the child's birth when the support obligation arises, or there may be equitable defenses that would apply.
I guess we'll see where this goes, but I'm not so sure that Mr. Beek's reading is an unreasonable one, particularly in light of this court's past jurisprudence interpreting these statutes, albeit mostly in the form of memorandum decisions, at least since this current statute was amended.
Well, in the memorandum decision, the only one that I was able to find was again the Petro versus Giannini.
Well, let me draw your attention to a case, Montano versus Giuliano, which is 2011 Westlaw 2306617 from 2011. And one could read those two decisions and basically find that they are in conflict.
Yeah, and I apologize, I would not have found or looked for that case because it would be beyond the period of the applicable period under Rule 111C. We're not allowed to go back that far for unreported decisions. Be that as it may, we have A specified as one period. Mr. Beeks' argument comes back and says that the second section, the first section in B, which also carries a shall, is the same period. Well, under our rules of statutory construction, we don't look at something that would render one section redundant. We have to presume that the legislature was not purposely and frankly pointlessly repeating itself by addressing the same section twice. Again, I think our biggest clue on that is the fact that the legislature under that first sentence of B did not use the term past support. There it is again. Past support comes up twice in these statutes. A, the shall, and then the second section, the second sentence of B. To that end, Mr. Beeks argues that the second relevant period in subsection B is more than 3 years before the commencement of the proceeding. No argument there either. This is where it intersects with Valentine, which is mandatory precedent here. And as I pointed out, the statutes, notwithstanding the changes, they are not substantively different. The same uses of the word shall and past support in A would apply and mandate it going back. The only difference is the legislature obviously saw some problems with entering child support awards going back 18 years when a matter was filed just before a child was emancipated. That was a little burdensome, very understandably, on parents. Therefore, the legislature put in that 3-year presumptive period. We can still go beyond that, but that's not an issue right here. Bringing the argument forward to page 9, by mandating an award after the commencement of the proceeding and limiting the trial court's discretion to award retroactive support beyond 3 years, only if good cause is established, it implies that the trial court retains jurisdiction to award retroactive child support for a period of up to 3 years, absent good cause, etc. No, that argument is false for a simple reason. It would render the shall provision of subsection A meaningless. All of a sudden, the court would now have discretion on this when the court's discretion is limited by the legislature's use of the word shall. Now, on page 9, this is one of the more interesting statements in the answering brief. If the legislature had intended that awards of retroactive child support were mandatory, there would have been no reason for subsection B. No, that misses the point, because again, we are talking about a defined term, not a defined term within a statute, but in a defined term within a context that is, again, past support. Now, I can make that statement a truthful statement by pointing out what the legislature did. Again, quoting page 9 of the opening brief, if the legislature had intended that awards of retroactive child support were mandatory, it would have included the word shall. And it did in subsection A. I'd like to reserve the remainder of my time for that.
All right. Thank you, Mr.
Thank
Shields. Counsel.
May it please the court, Dan Beeks on behalf of the appellee, Jules Gelin, who I understand is watching us on YouTube right now. We've got a couple issues here today. The first, which counsel has spent pretty much all of his time talking about, is how do you interpret 25809A and whether an award of child support is mandatory or discretionary in what I'll call the 3-year period, which of course may be cut shorter if the child was born within that 3-year period, but I'll just call it the 3-year period and trust you all understand what I'm talking about. So whether it's mandatory or discretionary, that's issue number one. And number two, assuming you side with opposing counsel and find that it is mandatory, whether you can still affirm this judgment based on the unclean hands equitable defense that I'll be the first to admit nobody raised down below, but we're arguing you can affirm on any grounds supported by the record if the logic's right. And the
Well, if you
evidence
didn't
is there.
raise it below, why would we affirm? And I hate to jump to the second issue first, but just as a matter of course, if you didn't raise it below, you didn't give the other side an opportunity to respond to it, right?
I agree with the case law says if the reasoning's right and it's supported by the record, you can still affirm on
Well,
those
it might
grounds.
be-
I'm troubled by the waiver issue too, but I looked long
It
and
may be
hard.
supported by the record as it exists, but it doesn't do process and demand that you at least give the opportunity for the other side to file
Well-
a response to it.
Yes and no. If it was an issue that was totally not litigated below, we would have a real problem. In this case, however, the unclean hands is based on issues that were litigated, and there were actually 2 sets of findings by the trial court on. In 2 different rulings, the trial court found that mother had deliberately tried to absent father from the child's life and found that mother's actions in doing so had been unreasonable. So that issue was litigated, although not under the rubric of unclean hands. The trial court did make findings on those issues that were litigated and were disputed and of which mother did have notice and was able to litigate. So if it hadn't been brought up at all, I would have the same due process concerns you would have. But if we are using those findings that were litigated and of which they did have knowledge to make an unclean hands finding, I think the court can go there, assuming
They were litigated for the purposes, I mean, the worst that happens to mother in that case is that she's assigned attorney's fees. And that was the worst remedy that she could have weigh against her, where you're saying she should have known that the remedy would have been that she was waiving any right to ask for past child support.
Well, the issue was litigated in terms of whether in our view, the statute, the discretion in the 3-year period, and, counsel for father below argued trial court should exercise its discretion, not award mother fees because she cut father out of the child's life for those 3 years. And the court actually went on to find, and I think it's quoted in our opening brief, that, that misbehavior or whatever you want to call it ended pretty much when the case got filed, which would then justify the court's different treatment of the filing to entry of the support order period as opposed to the 3 years back to the filing period. Because under subsection A, unclean hands would in theory be an equitable defense that could have barred in both of those periods. But I think in this case, and the court made the findings, it found that that misbehavior justified exercising discretion not to award in the 3-year period, but not afterwards, because by that point, father was kind of back in the child's life. So unless anybody else wants to spend more time on unclean hands, I'll go back to the argument I think you should rule on, which will obviate the need to get to the unclean hands issue, which I'll be the first to admit is much more troublesome. In this case, 25809 has 2 sections. 25809A says the court shall award past support unless equitable defenses are applicable. The problem with subsection A is it doesn't define the term quote unquote past support. It doesn't have any exclusive list of equitable defenses. That was one of counsel's arguments, is that unclean hands wasn't a recognized defense. And number 3, and probably most importantly, it doesn't talk about the duration. It doesn't talk about the period for which that past support would be applicable, whether it goes all the way back to birth or what it does. So you have to find the duration, you have to look to subsection B. And subsection B, as counsel quoted from my brief, and which you probably all read, at least in our view of the world, breaks the court's authority down into 3 periods. The period from filing until the entry of the, what I'll call the establishment order, the order establishing child support, that's mandatory. The court shall do it. Then the second sentence goes on and says the court shall not award more than 3 years back unless it analyzes all the relevant circumstances, makes specific findings, analyzes 3 particular subsection facts. So you've got one portion that says you shall do it from this point on, another point that says you shall not do it back there unless something else. Doesn't say anything about the middle. What does that say? If you must do it here, you must not do it unless something else back here, it means you have discretion in the middle. The court has discretion in that 3-year period.
So to distinguish that from the third category of time, in other words, awarding support longer than 3 years
Right.
back, which requires written findings. Your argument is that with respect to that middle section, the court has discretion
Right.
to consider a request and to enter an award, but is not required to provide written findings to support that exercise of discretion.
Correct. That's how, at least I read the statute. It says beyond 3 years, you have to make those findings, and it doesn't say anything. You have to make it in either of the other 2 periods.
So if I'm understanding your argument, Mr. Beeks, your argument is that the court should read subsections A and B together, and that B implements the court's consideration of that issue that's stated in A.
Correct. I mean, if you accept mother's interpretation that past support is mandatory by A, then what does the first sentence of B add? Because under mother's interpretation, you're required to go back basically to birth under A, and then perhaps you can knock it out under the second sentence of subsection B, but she's saying it goes back at least to the 3 years under A, then what does that first sentence add? If it was mandatory in A, why are we saying in B, you must award, you shall award from the period of filing till the entry of the establishment order? And as counsel correctly noted, one of the well-known maxims of statutory construction is we have to interpret the statute so that every part has meaning and nothing is rendered redundant or duplicative of another section. And if you adopt mother's interpretation, that would be the outcome. I mean, look, if the legislature wanted to say you must award back to 3 years, they could easily have said that in the first sentence, right? Where they're saying you shall award, from the basically the establishment order back. They said back to the filing date. They could easily have said back to 3 years before the filing date of the child's birth, whichever came later. That's not what they said. Perhaps more importantly, and we pointed this out in our answering brief, you have to interpret this statute in connection with the parallel statute dealing with child support in dissolution matters, 25-320. And, the well-known maxim, you have to interpret statutes dealing with similar subjects consistently in harmony and the likes. Well, for all the world, it looks like the legislature was trying to match up those 2 statutes, and 25-320 makes it absolutely crystal clear that in that 3-year period, it's discretionary. It's a may. The statute says the court may order child support retroactive to the date of separation. What it leads in with if the parents are living separate and apart prior to the filing. And then it says the court may order retroactively to the date of separation, but not more than 3 years before the date of filing, after considering all the relevant factors that track what the relevant factors are in 25-809B. So I think you have to interpret those statutes together and think, would there be any logical reason the legislature would want children to be treated differently in these situations? You've got, under mother's interpretation, in every case in a paternity action, you'd have to award back 3 years. even if the parents had been living together during those 3 years, you'd have to award the mother child support, or I guess father, if it's not, you could have it in that situation, but the child would basically get child support for that 3-year period. Now, under the dissolution statutes, if the parents are living separate and apart and you don't have all the advantages of 2 incomes supporting 1 household and things like that, the child would not be entitled to mandatory. It would still be discretionary for the trial court. There'd be no logical reason that the legislature would have wanted that, and there's no reason for this court to stretch the interpretation of 25809 to reach a different result than what's in 25.
Would that be one of those equitable defenses that could be raised for in a paternity action that, well, we were living together during those 3-year periods?
Interesting question. I don't know that the case law answers it. I mean, so far, for example, the Petrov versus Giannini case, or Petro versus Giannini case, has talked about what we would call, the traditional, Black's Law Dictionary equitable defenses, not so much just, we were living together at being an equitable defense. I would take your position that yes, that would be one of the equitable defenses that you could talk about, but it's certainly not clear under the statute. But why would a child in one set of relationships have to basically prove it as an equitable defense and the other child get it automatically? There's no reason the legislature would seek to distinguish it that way.
I would think the answer is it's not a traditional equitable defense.
I would probably agree with you as well. And it's not one of the factors listed under at least the more than 3 years section either. So going to the Petro versus Giannini case, the case is troublesome. The case was a mess. The trial court in that case started off looking at the wrong statute. It was a paternity case, and the trial court cited to the dissolution statute, 25-320. Court didn't award any past child support for the period from the filing to the establishment order or anything back beyond that. Now, because it was actually a paternity action, the only way you could justify that result was whether if you found under 25809A that there was some kind of equitable defense. The court found, well, you can't get there from your record based on what you've got. What's important for this court to keep in mind, though, is the Petro case does not discuss this 3-year period at all, except in a footnote number 3, in which it says that the award during the 3-year period is presumptive. It doesn't appear that issue was briefed, argued, litigated at all in Petro. And the language about presumptive, I'm not sure what you make of that. I suppose, at least to me, presumptive means it's not mandatory. It's a starting point, but the court has discretion not to go there.
Well, what you're really saying, Mr. Beeks, perhaps, is that footnote language is dicta.
That's exactly what I'm saying, and that's exactly what I said in my brief. The issue was not litigated. It was not part of the court's analysis. The court in that case, and it really wasn't that. In that case, they weren't even looking back for the full 3 years because the child wasn't even 3 years old. They were only looking for 33 total months between the filing to the establishment order and the back portion. So it was dictum. You're exactly right. And again, we're talking about a memorandum decision, intentionally not published, intentionally not intended to be precedential. And like opposing counsel, I hadn't looked back to 2011 cases, but it sounds like it's even conflicting with other memorandum decisions interpreting the same statutes. The Valentine case, obviously supplemental authority, not very helpful. Counsel provided you all with the statute as it read back then, and subsection B just had not yet been adopted by the legislature at that point. At that point in time, 25809 just said the court shall award past child support, and there was no separate section dealing with the durations, the current subsection B. So the language that it's that past support was mandatory is relatively unremarkable, given that the statute said the court shall award past support under the statute as it existed at the time. That doesn't really help the court interpret subsection 25809B today. The last argument I'll deal with on that is, and I'll give it to opposing counsel, it's a fairly creative argument that past support is a term of art in the statute, and it is somehow distinguished from support determined to be due for the period between the commencement of the proceeding and the date that the current child support is ordered to begin, as provided in subsection B of 25809. Looking back at the history of the statute, I don't think that's the case. The term past support was always there, and I think this fact that it's really not whatever magical language or intentionally specific language like that is disproved if you look at 25320. And in that case, if you look at 25320B, which deals with the period from the filing to the establishment order, where again it's mandatory, that subsection of the statute calls that same kind of support two different things. It calls it past support, and it calls it retroactive child support. So the argument that past support has a certain and defined meaning that is limited to subsection A and subsection 25809B doesn't really make much sense.
Don't we have to read in past support in B? Otherwise, family case could take years,
right,
to litigate. So you could have interest accruing.
Well, if you're going to have interest accruing, you would have temporary orders establishing child support, because until
that's my point. If you don't read that as being past support and it's just a child support order going back, then any of those monies would be deemed arrearages rather than past support. It's got to be one or the other. It's either arrearages or past support.
Yeah, I tend to agree with you, and I think there's real problematic applying interest on things until it's been liquidated, but that's an issue for another case, I guess. All that being said, it looks like I'm about out of time anyway, so if anybody has any questions, I'm happy to answer them. Otherwise, I think you need to read the statute as having three time periods. That's what the legislature intended, and the other interpretation just makes no sense. So thank you.
All right, thank you, counsel. Mr. Schultz.
I apologize for being in front of the wrong lectern. Old habits die hard. With respect to the affirmative defense of unclean hands, it was never raised. It was never pled. In fact, the term equitable defenses was never pled. Neither equitable defenses nor unclean hands appears anywhere in the transcript. No, they cannot raise it. Not only that, the opening brief went through multiple cases that do cite the recognized equitable defenses. Unclean hands is not one of them. It never has been one of them. I can't imagine how it ever could be one of them, because Judge Bailey, Judge McMurdy, you remember your days on family court. Maybe you're trying to forget them. A lot of people wouldn't blame you for that. But the reality is we cannot make child support a child's right. We cannot make that an issue of equitable. Does someone really deserve it or not? And frankly, that's another problem that runs throughout all of Father's argument. He seems to have lost track that child support is for the sake of the child. Now, with that in mind, with that policy, with that legislative mandate, because we're dealing with the word shall, we should be looking at these statutes in a way that is as expansive, as liberal as possible. Why? Because it's for the sake of a child. We should not be trying to limit it. That's why the cases that deal with equitable defenses say they should be applied sparingly. Now, ideally, I will admit, the legislature could have made things easier by putting the second sentence of B at the end of A, rather than putting it in B. That would clarify things. That would leave little doubt. Still, let's look at what the court said in B, because you're right, Judge McMurray, it's one or the other. The court shall enter an award of support to be determined due for the period between the commencement of the proceeding. What word is missing from there? Past. The word past support is missing from there. Clearly, this is talking about a period that is separate, that is distinct from both A and the second sentence in B.
Counsel, what if we were to read, I mean, A has been, you gave us the history of the statute, and A, in about the same way, has been present in the statute, and they added B, right?
Correct.
So if B is just a clarification for timing only, A's always been there. You have to calculate some sort of retroactive support for the child, and you have to tell them how they're going to pay it, and you have to use the child support guidelines. This is how a judge would enter past support. And then B clarifies and says, okay, we're going to come in and say, because there have been issues, it's mandatory for this period. If you're going to do it more than that, you have to make findings. Why shouldn't we read it like that?
Because I remember this from my first year of practice when this statute changed. Prior to that 3-year period in B, they were going all the way back to a child's birth. And again, that was overburdensome. So I believe, it's more than a belief, it's quite clear what the legislature said is that is onerous. We're going to cap it at 3 years absent circumstances. That's what we have here. Again, it's the only way to read it. It's the only way to understand Valentine. It's the only way to understand Petro. I take issue with the statement that these 3 years weren't at issue in Petro. That was my case. I argued it. I won it. Judge Swan, who signed the order granting oral argument, was the author of that decision. I lifted much of my brief in Petro for the opening brief in this case. I know exactly what was at issue, and yes, the 3 years were at issue.
Judge Swan is also the judge who authored Beeks, the case, the 2011 case that goes the other direction.
I can't speak to that because we're not allowed to go back that far. You certainly have my curiosity, though. I will look that up when I get home, but he spoke very clearly in Petro, and yes, that was the exact issue. Mother argues that retroactive support was required under 809A. We agree. That term presumptive 3-year period, I guess I'd like to think that I'm the one who coined that, and that's how it ended up in the footnote. Regardless, that is exactly what was decided there. It is exactly what was decided in Valentine, except, as you noted, Judge Bailey, 809 at that time was not presumptively capped at 3 years. It went all the way back to birth, which is why we have the specific language in there. Again, however this court wants to consider Petro in that 2011 case, Valentine is mandatory, and it answers every necessary question before this court. What I want to point out with the short time I have left is 25-324 as it applies to this case. My client's income has been adjudicated as an attribution at less than half of the father's income. The vast majority of my practice is everyday people like my client. I want to be able to help everyday people like her. Making $3,500, she makes less than that, that's attributed. You cannot pay a lawyer and raise your family on that kind of income. I want to put emphasis on our fee request for that for the very purpose under 25-324. I did not request the oral argument in this. I typically don't because, again, most of my clients are everyday people, and oral argument preparation is very expensive. Again, that is important for this court to note under 25-324 and our request for fees. As we're going back to the statute as it existed in 1997, they were mandatory at that point. Now the court has its discretion, and I certainly believe that the court should exercise its discretion in favor of awarding fees. Again, Valentine is mandatory. Yes, the legislature could have made it more clear by putting the second sentence of B at the beginning of A, but there is no other way to read this case that would not render part of the statute irrelevant, or that would not contradict it, or simply put, render the shall in A as useless, as meaningless. It is not useless under Petro. It is clearly not useless under Valentine. Does the court have any questions for me? Thank you much.
Thank you, Mr. Shield. The case is deemed submitted. We'll issue a decision in due course. Thank you, counsel, for your brief.